Thank you.
SJC-11439, Kenneth D. May et al., v. SunTrust Mortgage, Inc.
Yes, counsel. Good morning.
Good morning, Your Honor. Good morning to the court. My name is Ken Quad. I represent Kenneth May and his wife, Valerie Corbin May. This case stems from a 2005 mortgage refinancing on the plaintiff's home in Brockton. It's undisputed in this case that under the Massachusetts Consumer Credit Cost Disclosure Act, MCCDA, the plaintiffs had a right to rescind the transaction within 3 business days of the closing. That's provided in Section 10 of the statute. Rescission is one of MCCDA's most fundamental consumer protections, giving borrowers a period of time in which they can reconsider a transaction that has the potential to cause the loss of their home. The legislature, in fact, concluded that rescission is so important that borrowers are given up to 4 years to rescind, 4 years from the date of the closing.
But isn't that the statutory rescission right depends on not being provided the disclosure, the proper disclosure forms and the information that's in the statute, correct?
That's the extended rescission right. The initial 3 business day rescission right is automatic. It's a given. It exists regardless of the lender's compliance with the statute.
Right. But once you get beyond that,
Once you get beyond the 3 days.
then you're into this other world, right?
That's correct.
So my question, I guess, to you is, at least and this is my question.
Mm-hmm.
It seems from the record, and that we're talking about count 3 of your complaint.
That's right.
Which relates to the form that you said that your clients had to sign about, we've already done this
Well, the statement of non-rescission.
statement of
Right,
non-rescission. But they got all the or at least because counts 1 and 2 are gone, they got all the disclosures that are sort of mentioned in the rescission part of, I think it's section 10 of the statute, correct?
Well, not actually true, Your Honor. And this is the reason. One of the fundamental requirements of the statute is that the borrowers receive clear and conspicuous notice of the right to rescind.
Right.
So the contention in count 3 of the complaint, second amended complaint, is that the statement of non-rescission actually negated the disclosure of rescission rights.
Oh, okay. I get it. So you say, in fact, this fits within the statute.
Absolutely.
Okay.
And the 3 reported cases that have addressed such a question would concur with that
I mean,
conclusion.
in a way, it doesn't matter because the reported question doesn't depend on that. I
The reported question
appreciate that
doesn't
fact.
really have to do with the substance
Right.
of of this particular rescission claim per se. We'll get to that further on summary judgment or a trial, depending on how this court rules on the certified question.
Now, procedurally, your client brought this action where?
This action was brought as an adversary complaint in bankruptcy court.
I guess I don't understand what that is.
Well, an adversary proceeding essentially is the commencement of a civil action within the context of a bankruptcy case.
Okay, so you commenced an action against SunTrust seeking to rescind the mortgage.
Right. What preceded the filing of the adversary complaint, and I would add parenthetically, that the filing of an adversary complaint was probably not even necessary because in this case, the lender had filed a proof of claim asserting a security interest in the property. My clients objected to that proof of claim on the grounds that they had a right to rescind the transaction, and therefore the loan was not secured. That in itself could have become a contested matter within the bankruptcy court. We did file an adversary complaint to have it proceed as a separate action.
So it's not really being, I mean, my question was, it's not really being used defensively, it's being used offensively.
Well, no, Your Honor, I would disagree. It's being used defensively in the sense that it was in response to the filing of a proof of claim in bankruptcy court asserting a security interest. Also, that there had been a foreclosure proceeding started against my client.
So,
I need one little bit of clarification about bankruptcy procedure. Who was the petitioner in bankruptcy, your client?
My clients, well, initially are the debtors in bankruptcy
Oh, okay.
in court.
Okay.
Right.
so it's a Chapter 13.
This is a Chapter 13 case.
Yeah, it wasn't SunTrust that was in bankruptcy.
No.
Okay.
SunTrust is the creditor.
So let me just play out how this would work if the answer to the question is as you wish it to be. And assume that you don't, on the merits, you get to where you want to get. So you would say this is defensive, correct?
Yes,
In recoupment.
yes.
So you would say we have a right to rescind. So SunTrust pay back the finance charges and all the whatever we've paid, and that's what gets sort of set off against the 300 or 200,000, 300, whatever it is, right? And then you've got to tender the remainder in some form, or ask the judge to figure out a repayment plan that you could do. Is that how it
That's
works?
essentially correct, Your Honor. Yes, that is essentially correct. If rescission is granted, then any finance charges which have accrued but are not yet unpaid, more an arrearage, so to speak, would be canceled. Any funds that the plaintiffs have already paid in the nature of finance charges would essentially become a credit back to them off the principal balance, and then there would be left essentially a post-rescission balance, which then the bankruptcy judge would have discretion with respect to how it gets repaid.
Well, now, what if you had spent, or what if your clients had spent the proceeds of the mortgage loan to improve their house, something like that? Does that affect the outcome here?
No, it really doesn't, Your Honor. The only issue with respect to the purpose of what the proceeds were used for is whether it was within the traditional consumer purpose, defined as for personal, household, or family
So
purposes.
it's a second mortgage, or it's a refinancing?
It was,
it's not
here it
yet.
was a refinancing.
Okay.
It was a conventional
Yeah.
refinancing.
Why would the legislature make it quite clear that this right of rescission expires after 4 years if it was going to essentially undo that through the right of recoupment?
Well, my response to that is that the legislature clearly believed that where the loss of a home is at stake, in other words, where the homeowner is in a defensive position, faced with the loss of a primary residence, that limitation in Section 10F should not apply. So it made a distinction. It made a public policy choice that we're not going to let homeowners exercise rescission rights affirmatively after 4 years, even if the violations have been egregious.
But this statute doesn't create a right of recoupment. The statute doesn't create a right of recoupment.
No,
It sort of exists out there at common law, and
It
is what it is.
preserves whatever rights exist in recoupment,
So-
correct? It doesn't create a rescission right in recoupment.
Exactly.
So why would that not be limited to a claim by SunTrust following foreclosure for whatever balance is still due?
That's what this is. Isn't that what you're saying?
Well, this is it's a foreclosure situation, but the foreclosure hasn't occurred.
Right, so I mean, let's assume the foreclosure, let's assume the amount due is $400,000, the house sells for $300,000. Why would this recoupment not essentially prevent them from suing you for the balance of the $100,000 after the, or they could do it, but you could take all your finance charges and they could be recouped against whatever amount is still due.
I'm not sure I'm following the question. So you're suggesting in a post-foreclosure, a foreclosure auction has occurred?
Right.
And there's a deficiency,
there's
and
Uh,
SunTrust
The
comes after you.
the house is gone, there are no longer any rescission rights. That's the short
And
answer.
so why would the recoupment not kick in if they haven't given you the appropriate notice? Why would that
well-
not, why would that not be what the common law would give you as a right of recoupment? That is, that if they don't disclose something properly, that they can't get anything beyond the foreclosure, but they're not going to be able to get the recovery of, say, the finance charges which arose from this contract.
I think I'm still having a little trouble with the question, but I'll do my best.
It's a deficiency. The question is basically,
Yeah.
why is the effect of this essentially, they can foreclose, but they lose any right to get the deficiency? Why is that not an appropriate harmonization of this language of the statute?
Because at that point, there's no rescission. This savings clause in section 10I3 is within the rescission, is within section 10, which is solely a rescission-based section of the statute. We're not talking here about attempting to set off or recoup deficiencies. That, in fact, I believe that this savings clause would not even be necessary to do that, because let's fast forward to a suit on a deficiency after foreclosure. The only available rights which a homeowner would have, or the former homeowner would have at that point, would be potentially a suit for damages, a counterclaim for damages under Section 32 of the statute, which might result in some minor offset, but would certainly not defeat the claim for deficiency.
Can I ask you a question? But if you have it's about, assume your reading of the statute that you can do what you want to do within the bankruptcy proceeding. What do you make of the difference between the 1635F, which talks about rescission in recoupment, and our statute that leaves out the rescission in recoupment and just talks about recoupment? Do you know what I'm trying to say? 10I3 is a little different than 1635F.
I think so. Let me just, I have a copy of 1635 here, if I may just have 1 second.
It's not F.
Yeah.
It's I3 again.
Right, right. And that's actually one of the two differences between our section and the federal section. Our section states that nothing in this section affects the consumer's right to recoupment, as opposed to the federal statute, section 1635. Nothing in this subsection affects the consumer's right of rescission. I think that the federal statute could be interpreted to mean that since subsection I of the federal statute only talks about rescission rights in foreclosure, conceivably the federal statute is limited to that. I don't know what to make of the absence of the word rescission.
Do you know
in
of
our
any, I
statute.
mean, I haven't
I'm
done,
not aware of
I
any
have not
cases that
done
have-
any extensive legislative history at all. But whatever I've done, didn't come up with anything about this. Did you have any legislative
I don't
history as
have-
to why that language wasn't incorporated into our statute?
I don't, Your Honor. I can't provide any insight into that.
The problem arises here, isn't it, because the foreclosure and then your adversary proceeding happened after 4 years. There'd be no question that the rescission remedy could be raised, whether in an adversary proceeding or otherwise, if it had been 3 years.
Right.
The sole question here is the impact of what happens if, well, so, and I gather that your point is that if the foreclosure proceedings and so forth just happen to take place in year 5, and the creditor is moving forward, you should be able, on that basis, because the statute provides a remedy for recoupment, which is used in an affirmatively defensive, in a defensive posture.
Yes.
If they bring the case, then you should be able to defend it with this.
That's correct, Justice Link. And the bankruptcy cases talk about the fact that so long as the creditor's action is timely.
So I'm sort of grappling for context. What is it that you really hope to accomplish here? You want to avert the foreclosure?
Well, we want to save the house. We want the bankruptcy court to eventually
But you're going to be doing that indirectly somehow.
We want the, right, the bankruptcy, if we prevail on the merits,
Yeah.
the bankruptcy court will ultimately have discretion to take whatever money remains due to SunTrust and decide on an equitable way to repay that. Now, that could be, if the equities are mostly with SunTrust and not with my clients in terms of the fault and my client's attempts to keep up with the mortgage, whatever all the equities are, that the court could very well say, okay, well, you've rescinded, pay the money back in 6 months, which they're probably not going to be able to do.
And you lose
So
the
you're
house.
looking to
house anyway.
reduce the total amount that's in default?
It would ultimately reduce the balance.
And maybe give the bankruptcy court the authority to stop the foreclosure and allow you to pay that money back over a period of time?
Correct.
The foreclosure is stopped right now.
It is because of the automatic stay
Right,
in the
right.
Yeah,
bankruptcy court.
but stop it permanently in exchange for, as a remedy,
Correct.
other than the automatic stay, in exchange for your paying out that debt
Correct.
over time.
So you're looking essentially to rescind the transaction? Isn't
That's
that what
right.
rescission means?
Yes, that's right.
Rescind it.
That's right, rescind it.
Well, recoupment
Bring
has
the
nothing to
parties-
do with rescission.
Well, recoupment is a general common law concept.
Equity within a transaction, not
Correct.
voiding a transaction.
That was one of Judge Bailey's points in
Right.
O'Connell. He believed that this really, that rescission somehow does not stem from the original transaction, that it's a whole separate being. and
So if
we
you
disagree with that,
rescind,
obviously.
if you rescind, there's no mortgage. Or does it revert back to an earlier mortgage?
The plain language of.
Owes the money.
Before I lose my train of thought, I just want to make clear to the court that rescinding defensively does not mean the homeowner, the consumer, gets the same panoply of relief that he or she would get in an affirmative case, because there are no attorney's fees, there's no damages.
But
All we
does
can do is-
rescission here wipe out the secured interest of the mortgage?
It may or may not, and I'm not avoiding the question. The plain language of the statute says that upon rescission, the security interest is void. But if you look at the cases, both under the State Truth in Lending Act and all the federal cases, you will see that what many judges do is keep the security interest. They think that language can't mean what it says, it's too draconian. So
So I
Be
think
many bankruptcy
it's part of the equity, it's
Sorry,
part of the
different-
equitable arrangement that
some judges
happens.
believe that they can reorder the,
Reform the note.
essentially modify the mechanics of rescission and keep, and not prejudice the lender unduly, keep the security interest in place until the tender requirement is in place or has been satisfied in some fashion.
Mr. Quat, your time is up.
I understand that, Your Honor. Thank you very much.
Good morning, Your Honors. May it please the Court. Attorney Natalie Salomon on behalf of SunTrust. I think you've correctly, Justice Lank, explained what the issue here is. It's not whether or not the Mays can seek a rescission of their loan transaction within the 4 years, but it's whether they can do so, still raise a rescission claim after the statutory expiration, which is 4 years, if they do so defensively by way of recoupment under common law. The answer to this question is no, for at least 2 reasons. And I think Justice Cordy and Gantz, you've touched upon that, is that the statute itself is very clear that the rescission claim expires after 4 years of the closing. It can expire even before if the property is
Well, that's the
sold.
affirmative rescission claim. Right?
Yes, it expires, absolutely. Now, if it's raised affirmatively, that's correct, Your Honor. Now, the second reason that it cannot be, a rescission claim cannot be raised after the statutory expiration is because rescission and recoupment, as Judge Bailey explained in O'Connell, are two different concepts. They are apples and oranges.
Well, let me just ask you that about,
Yes.
this about that. In the Beach case, the United States Supreme Court case, the way that the court decided that case was to say that the 1635I, or I'm sorry, the rescission right in 1635 was a statute of repose. The 3-year limitation in the Federal Act was a statute of repose, not of limitation. It did not say this doesn't work because rescission in recoupment is a apples and oranges situation. You can't do it.
Well, I think the Beach decision is very important because if you look at both provisions, Section 10F, which talks about the expiration time, and Sections 1635F, they are identical, but for the duration of the claim. It's 3 years under the federal statute and 4 years in state, under state law. And I'll answer your question. I understand that you are talking about recoupment, but under the Beach decision, the court said that the provision is clear and straightforward. It doesn't just talk about the right of rescission and the time during which that right can be exercised. It talks about or rather governs the life of the underlying claim, which is the rescission claim.
Right.
So on the Beach, and I would suggest that it's the same here, the rescission claim is over
So
after
you
4
treat it as a
years.
statute of repose.
That's correct. Now, to answer your question regarding recoupment, and I think Justice Cordy pointed that out earlier, is that Section 10I3 talks about, and you did so, Your Honor, too, it talks about the fact that that section does not affect the consumer's right of recoupment. The legislature did not say expressly that this section does not affect the right of rescission under or by way of recoupment. That language is missing. And it's for a reason. If the legislature wanted to provide the obligors.
Is there any legislative history that you know of that indicates why that isn't in there?
Well, simply because they chose not to do so.
I
There's
just-
none. I don't know of that, Your Honor, and I understand that Attorney Quatz did not provide any explanation for that. But the fact of the matter is that it's missing. That language is missing.
But can I ask you this? I mean, I've read Judge Bailey's sort of view of how this works. And so what's your view of what the legislature was referring to when it said the right of recoupment under common law?
Well,
What is it
what
in
is
these
it?
contexts?
I think I refer to the Black's Law Dictionary definition of recoupment, which is essentially a right to monetary relief. It's the right of a defendant to a deduction from the amount that the plaintiff's from the amount of the plaintiff's damages if the plaintiff did not comply with the contract.
But wouldn't that be what he's seeking here? In the sense that if there's a rescission, any finance charges that have been paid would be a credit against the principal debt still outstanding.
Well, what the Mays are seeking here, actually, Your Honor, is not just a monetary relief. They are seeking to void a transaction. They are looking for an affirmative relief. And I believe that this court in Bose explained that recoupment under this common law does not include or does not result in an affirmative relief. So that's what they're looking for, to void the mortgage, to void the note. Now, as Judge Bailey explained, monetary damages or relief can flow from rescission. You can obtain damages, and there's an exchange of money, but in itself, by its own nature, rescission is not the same as recoupment, because you are voiding, you are undoing a contract. And I will go back to the line of questioning that you had regarding what happened next. Under the statute, once a rescission is granted, the contract is void, and I think you've addressed that. The note and the mortgage are gone. So legally and procedurally, I don't see how a bank can foreclose because it no longer has really a mortgage and a note. What it does have is maybe a payment of money under the proof of claim, but that in itself is not a secured debt. In fact, the statute explains that once rescission happens, the bank has to discharge the mortgage. It then becomes an unsecured creditor. What it's left with is so-called damages, which would be the amount of the debt, but it will be part of the pool of unsecured creditors. And in bankruptcy court, what will happen is that by equity, the judge will decide what the bank will be entitled to, and it will depend on what the debtors have. But in the meantime, whatever amount of money the bank had received, it will have to give it back to the debtors. The bank will have to discharge the mortgage. The loan and the mortgage will be void, and what will be left is the decision of the bankruptcy judge to decide what inequity should be given to the bank. And I think that's what Judge Bailey explained, that inequity, this doesn't make any sense.
Yeah.
Who owns the house? Out of
Well, the
curiosity.
house legally is owned by the debtors, and the house, in fact, no longer has a lien. It no longer has a mortgage on record because the bank will have to discharge the mortgage.
But if you say that recoupment and rescission are not the same, they're very different.
Yes.
It sounds as though there may be a remedy in the nature of recoupment that can reduce the amount of indebtedness that the debtors owe to the creditor, and yet keep the mortgage in place, and the bankruptcy judge still has equitable powers to prevent the foreclosure, apart from the automatic stay, to prevent the actual execution on the security interest, and give them a fixed amount of time and a schedule in which to pay back the indebtedness that's certain.
And if they don't, the foreclosure
The foreclosure
goes
goes forward.
But that would be outside of rescission. What they're looking here is to rescind the loan transaction. It is conceivable that under the common law recoupment, a judge could look at a secured debt and say, to the extent that the debtors can actually prove that they were damaged, then they could obtain a judgment, and that judgment would reduce the amount of the secured debt. But that can be accomplished outside of the rescission.
Can it be accomplished through recoupment?
It could, but that's not what they're looking for here. They're not
Well,
looking to...
how would it be, how could it be accomplished through recoupment? Under your theory, well, how could it be?
Well, it would have nothing to do with rescission, right?
That's correct, Your Honor. Yes. Let's say, I'll give you an
Would it be
example.
a damages claim?
Well, it could be. I mean, if you have a suit on note, so the
No, but
bank
in this context, you've got, that's what you've got, is a suit on the, I mean,
No, it's not a suit on note in this particular case.
Okay, so in this context, how would it work?
The recoupment outside of rescission, I think that if they can, if the debtors could prove that they were damaged by whatever violation they claim occurred in this case, a judge could potentially award an amount that would be deducted from the secured claim. and would help in reducing the amount of the claim or the amount of the debt. But that can be accomplished completely outside and should be accomplished outside of the rescission.
But the problem really, I think that we're struggling with is that there is a right of rescission in the statute that is
That's correct, Your
granted.
Honor.
And it's in that very statutory context
Yes.
that our legislature has said, but the common law rights of recoupment are not going to be affected.
Yes.
So it's not like they were thinking about recoupment in some other context. It was within the context of exercising the right of rescission.
Well,
So that's the puzzle here, how to reconcile what seems to have been some legislative intent here to keep the doctrine of recoupment alive in the context of a right of rescission.
well, my understanding of the statute is that this is not just a statute about rescission. It's a statute about the required disclosures at the time of closing. What the statute provides is two types of relief. You have a relief by way of rescission, and then you have relief by way of damages, which in a way, it's very similar to recoupment because what recoupment is a right to monetary relief. So you can still envision recoupment and damages in the context of the MCCDA, but without getting the other relief, the rescission claim, because it has expired.
So you can, the request for rescission can be denied, but in the context of the entire lawsuit, recoupment can reduce the amount of the claim.
That's correct, Your Honor, to the extent that some of the required disclosures have not been provided. So it's the distinction there, that there are really two types of relief that can be granted under the MCCCDA. And just to go further, really, if you look at the Act, there's nothing in the Act that compels the result that the debtors are now seeking, which is an indefinite right to repudiate and void the mortgage when the statute expressly provides for an expiration of the claim.
Is there an expiration of any claim as to monetary damages? I mean, I'm just trying in my own mind to play out what you're suggesting, which is
Yes.
that the debtor is there and saying, well, you didn't give me the notices you were supposed to have given. There was wrongdoing on the part of the creditor, and I can't seek rescission, but I can seek damages from you.
Yes.
And I can do that at year 6 or year 12 or wherever in a defensive posture whenever you've brought your suit. And then I'm not limited by that 4-year statute of limitations. Is that what you're saying?
For the damages, there's a difference between TILA and the MCCCDA. On the TILA, there's only a right, a 1-year statute of limitation to bring damages. Under the state statute, it doesn't provide for that same statute of limitations, but one decision that I know at least has viewed it as meaning that the right to claim damages expires after 4 years. But because the legislature stated that the section about rescission and damages does not affect the right of recoupment that may exist under the Commonwealth, then arguably defensively, to answer your question, after 4 years, a consumer can still exercise his right of recoupment after the 4 years, but it would have to be done defensively, not by bringing an affirmatively an action for damages.
Thank you, Counsel.
Thank you, counsel.
Thank you.
We'll take a break.